Okay, just give me a minute. We're going to start in a second. Before I go into the presentation, there is a chat panel that should appear on the right side of your screen. If anybody who's sitting in attendance could type a message into the question section that you'll see sort of in the middle to let me know that you can see and hear me, or you can see the screen and hear my voice. I'm going to wait a second just to make sure that the audio and visuals, okay. All right, I got some responses. Okay, so it looks like we're good and ready to go. So I want to welcome everybody to the Micklin Law Group's monthly webinar series. Tonight's webinar is the modification of your property settlement agreement, do's and don'ts. We do these seminars once every month, usually the last Thursday of the month, depending on the holiday and other schedules, but usually this time also. So just give it a second. I'm going to jump into giving you just some explanation what to expect in case you haven't been here before. So today's webinar is scheduled for an hour, 6:30 to 7:30. I do my best to stay inside of that time frame. Sometimes it's less, sometimes it's a little more, but I do my best so that you can keep to your schedules also. I also will break 10-15 minutes early, hopefully, so I can take questions. I would urge you to post your questions where you just typed in that you can see and hear me, even though I won't be answering them at the time that you post them. I'll get to them at the end, but that way you make sure not to forget them. I will take as much time as necessary, even if it's beyond the hour that it was scheduled for, to make sure I answer all of your questions. I did have somebody email me some questions before today's webinar that I'll also address at that point in the webinar. As you can tell, you can't see me, I can't see you, you can hear me, but you can't hear, or I can't hear you. I believe you are all muted. I also want you to know that nobody else, I believe, can see that you're in attendance either. So your chat panel should only have your name, so you don't have to worry about confidentiality or any issues like that. I am recording this. I post them on my website, MicklinLawGroup.com. Usually a week or so after we do them, they'll also appear on our YouTube page around the same time. So if you don't get all the information, you can review it again. And also if you want to go back over and hear other points. All right, so that being said, let me give you a little background about me in case those that are in attendance, some of you may not know or have worked with me. My name is Brad Micklin. This is me. I am the managing member of the Micklin Law Group. I've been practicing law somewhat over 20 years. I'm a member of New Jersey State and Federal Bar Associations, or state bars, and licensed in the state and federal courts to appear. I began my law career as a law clerk for Judge Eugene Austin. He was the supervising judge of special civil litigation. From there, I went to Kessler & Associates in Clifton, New Jersey. I did complex commercial litigation for a number of years. Found that while I liked complex litigation, I didn't care much for representing businesses. I like working with people. So I transitioned from there in about 2001. 2001, opened my own office. At that time, I was a sole practitioner, which means I did a little bit of everything and by myself. Then a year or two after that, I realized that I wanted to concentrate my practice into divorce, family law, and estate planning issues, which is where it is today. The Micklin Law Group itself is also concentrated in those areas solely, but we have a number of associates that work underneath me. I handle the high conflict and high asset issues, and my staff usually handles the more simple matters or less complicated. I've been fortunate to receive a number of awards over the years, sort of age from right to left. The ones on I'm not actually sure how it faces you, but on my left where it starts with Premier 100, those are my more recent awards or accolades. The ones on the right are actually dated in 14, but I have received those each and every year since then. I just haven't updated the slides. I put these here not to boast or to make you try to think I'm maybe more or less than I am, but for those that don't know me or those that may come to work with me, I think it's important for you to know, especially even those that are listening tonight. It's important to know the person that you're listening to and to get some sense that I do have a good sense of what I'm talking about. I have been doing this for a very long time, and I try to put not just legal information, but some practical and realistic information based on a couple decades of experience. So let's jump into what we're going to do now. For those that may have attended my webinars before, I normally will have a very long list of what I'm going to cover, but this webinar tonight's going to be a little more practical than most. It's going to be less formal. It's going to have less legal jargon, less statutes and cases, and just more practical, sort of from my experience, application. So my slides for what the do's and don'ts are going to be kind of simple. One is do and one is don'ts. So that's essentially what we're going to be covering tonight. Not so complicated. So I'm going to focus more on the do's. Obviously, that's the most important for people, is to know what to do. Learning what not to do is important, but secondarily. So, and remember, this is a webinar based on modifying a settlement agreement. And that generally means that you've gone through the end of a divorce and you have an agreement in place. It can also apply in many cases to almost any settlement. So even if you were not married and you have an agreement, or you have a consent order, or even if you were divorced, but later you entered into another agreement or another consent order, much, if not all, of what I'm going to talk about will apply to those circumstances too. So it's not really just going to be limited to modification of agreements, but we're focusing on that because that's the more complex situation and also probably the more common. So what is the first thing that you should do? And that is speak to an experienced family law attorney. And I don't say that because I am one. Those that have met with me and worked with me know that I am the first one to tell a client if they do not need me, if the services are going to cost more than the result's going to be, but you want to know that. But you want to speak to somebody, and not necessarily to hire them, but to understand it. You want to know what the laws are. It's not just a question of going into court and telling the truth. I say this to all my clients in almost all the cases that we handle. It's not just telling the truth. Obviously, that's a big part of it, but it's how you tell the truth. It's what truth you tell. It's what documents you attach to your application. If you don't know this, you're never going to succeed, even if you're right, even if it's necessary, even if it's crucial or life-threatening, if we're talking about child issues, for instance. Next, you want to know what the statutory amendments have been. And this relates mostly to alimony. New Jersey's alimony statute underwent a significant revision a number of years back. And it sort of attempted to codify a great deal of the laws the cases that were in existence, as well as the practice of alimony settlement and trials, and put it into the law that exists now. And it's very important to know the differences when you're talking about alimony. There's also been a lot of changes over the years to some custody issues in case law and relocation. So at least I think you need to, one, speak to an experienced attorney, but also up to date on the laws, especially with those three issues, because I know for a fact that there have been significant changes to those specific areas. And the reason is you want to know how it applies to you. If you settled your agreement at a certain period of time, you did it based on the law that existed at the time. And that may be significantly different than the law that exists when you're seeking to modify it. So you need to get that. You also need to know not just the law, but what made the law, the facts from those cases that made the law, and how they apply to your case, so that you can understand and know in advance whether or not you're even entitled to the modification, and if you are, what you need to do in order to get it. So more on the do's, and let's talk about some of the financial issues for modification. This is the alimony statute that I mentioned a moment ago, and like I said, had been revised significantly over the last few years. If you are modifying a settlement agreement that predates the modification or the revision, I shouldn't say modification, the revision, you definitely want to speak to an attorney that's well versed in the statutory law so that you can see how it applies to your case. You may want to even talk to the attorney that represented you when you first drafted the agreement, even though that person should not be the one who represents you in the modification, because he or she could actually be a witness to the agreement, but it may help you to get some understanding of what was going on at the time, what the discussions were about, maybe some notes from the attorney that was involved. So let's talk a little bit about the alimony, the new changes, at least the significant changes. One is it's called now. There's a term called open durational alimony. Up until this point, there was permanent alimony, or the term permanent alimony, but it was not necessarily permanent. It actually wasn't permanent because there were changes. Times it could be modified or terminated. So they changed it. Instead of calling it permanent, we now call it open durational. Not going to go into all what that means because it's sort of outside the scope, but there are webinars on our website, MicklonLawGroup.com, that go through the alimony revisions, both before I think I did one and after the new law went into effect. One of the changes, though, it did make more significant changes. It discusses the status quo. There used to be an unequal balance. When the lower earning spouse needed support, they would try to maintain that person's lifestyle. Comparable lifestyle would be a term you'd hear often. Now the statute says neither party is entitled to any greater status or standard of living, so that it's more equal. They also now look at what I call PL supports, Pudende Lite supports, which is the support payments that occur during the course of the divorce that now can affect alimony. Now we're talking about modification. It's usually after the fact, but this may be something that you want to look into, because when you settled your case on alimony, it did not count, or probably did not include the Pudende Lite payments. So it's one more issue to look at. There are new provisions regarding loss of jobs and reduction of income. It used to be a much more rigid standard to go and modify your settlement, your alimony. They've now reduced the length of time you need to wait. They also made different characteristics for individuals as opposed to self-employed individuals. There are new provisions for self-employed individuals. So modifying for those types of situations are another different. Changes with cohabitation of another spouse. They've now provided for how it can terminate. I think they've also provided that it can be reinstated after if the court has terminated, but the cohabitation ceases. And this is an important one because the law that existed at the time of most settlement agreements was very different. Some people do have provisions about cohabitation in their agreements, some do not. So that's also an important point to discuss before determining if cohabitation is a grounds for modification. Retirement presumption, that is now at 65. Generally speaking, they put a lot of changes in about retirement. They put in provisions for those that may retire at a different age than common, like, for instance, police officers who might have their 20, 25 years in, but be in their mid-40s at that time and going for retirement. They also now allow anticipatory retirement. So before it was a question of you wanted to retire, but you couldn't because of support, but you couldn't get your support lowered because you weren't retired yet. So you were in this catch-22. You can now go to the court and say, I'm contemplating retiring, but I need to know if my support's going to be modified before I can do that. And the last thing that they put in that's always, well, not always, but mostly in many statutes is an exceptional circumstance warranting a deviation, sort of catch-all. There's obviously no meaning for this right now because the statute is new, but usually there's not many exceptions and many reasons that you'll find defining what is exceptional, but it's just good to know that there's always one catch. So moving past the money issues, and after you speak to somebody, what should you be doing next? Review and understand. Review and understand. The paperwork, basically. You want to read and understand your settlement agreement. Don't rely just on what the attorney you meet with speaks to or your spouse or partner says to you. Read it. As long as it is as tiring and difficult as it may be to read because lawyers wrote it, read it. Read the judgments and orders that may control, meaning the ones that may have come subsequently. So you have a past and a current understanding of your own case. You need to know and ask questions. Next thing I think that you should do when you're contemplating a modification is attempt to resolve it without litigation. And as I said before, even though I'm an attorney and this is what I do for a living, I'm the first one to try to encourage you to not need a lawyer and get it resolved. I think you should have a lawyer for the resolution and the paperwork, but there's nothing wrong in most cases with reaching out to the other side and trying to resolve it. Take into account what you think your legal fees are going to be if it's a money issue, and add that into the overall cost. If you're looking, for instance, to reduce alimony by $50,000 and you're going to spend $20,000-$25,000 to do it, you're half at a loss before you even start. It may pay you to use that money to buy yourself out of the issue and to avoid the litigation. And the reason I say this, and I think most lawyers are going to say this, even most judges will say it, is because you can agree to things that a judge can't order. Judges are bound by the law. Judges are bound by rules. They can't do things that are against those rules. You can, if you both agree, and there's obvious exceptions about public policy and best interest of children. But generally speaking, if the two of you agree to something and you think it's fair and reasonable, the court will allow it. Also consider mediation. Now I put mediation in here, but there are really many different options available to you. There's arbitration, there's collaborative processes, and there's mediation. All of these are out of court, usually non-binding, although arbitration can be binding, processes that allow you to resolve your issue. They most commonly will be done by either an experienced attorney or a retired family court judge. So you're getting the same type of experience in a court, but you're getting a lot less of a formal process. The rules of evidence are usually relaxed. The documents needed are relaxed. Scheduling is a lot better. It's an overall much better process. Any of them, mediation, arbitration, collaborative processes. I recommend most of them. In most cases, there's some exceptions depending on the nature of the parties involved, which I won't go into. If you need to know if you have a case that is or is not ripe for mediation or arbitration, obviously that goes to speaking with an attorney about it. Be clear and concise when you're filing papers and if you're ever speaking to a judge. The thing to understand about going into family court is there's always a lot of history to a case. There's always a lot of history, not just to the litigation, but to the relationship. And a lot of people want to bring that into their paperwork. They want to bring it into the court. They want to be heard and sort of vindicated. And a lot of times that has nothing to do with the issue at hand. And it makes it hard to follow that. If you have 20 pages in a certification and you're only allowed certain pages, you don't want the first 10 to be on how bad things were before you got divorced. If you're modifying a divorce agreement, talk about the reasons for modification. Now, that doesn't mean exclude the history that's relevant to understanding the agreement. That you want to include. But you don't want to put anything in that is superfluous. Nothing how bad the other person is or the problems that you had while you were together. Only that's relevant to the application. So now let's move on to talking about the actual filing and maybe some of the papers. So what do you want to do with regard to papers? First, file early if you can. The process for most applications for most modification applications is a very long one. Most often they require what's called a plenary hearing, which is a short but full trial. If you file a motion today, the motion will be decided within 1 or 2 months, most in family and divorce matters, maybe a little quicker in non-divorce cases, but figure 1 to 2 months because of scheduling. If it's granted, many of them will require that plenary hearing, which will be scheduled anywhere from 3 to 12 months later. In the meantime, or in the time between those two dates, you're exchanging information, you're taking depositions, you're maybe going to mediation, but you can be out a year before there's any change. So you want to start it as soon as you can in case you can't really wait that long. And the longer you wait, the worse it gets for you. Next thing with regard to papers, complete and file an updated case information statement. Now, if you went through a divorce, you should know what a case information statement is. It's a very long, tedious financial document that talks about everything from how much you pay in taxes to how much you spend on hair care. It's very important when it comes to financial issues, child support, spousal support, and modification issues. So you might want to consider doing this beforehand so that you can make sure it's accurate and have experienced eyes review it. It's in most cases with financial the most important document that the court's going to ask you for. If you are going to be filling one out, again, I did a webinar just on how to fill out a case information statement. It's also on my website, MicklunLawGroup.com. I highly recommend you watch it whenever you're filling one out, even if it's the first time you're filling it out because it's maybe new in a divorce case. Next, demonstrate a substantial change in circumstances. This is simply put the standard for most, if not all, modification applications. This, going back to what I said in the beginning, read and understand the case law. Just because circumstances have changed doesn't mean that they're substantial, and it doesn't mean that they warrant a review. So you need to understand and put forward the circumstances that existed when the agreement was reached and the circumstance that exists now. And an important point inside of this issue that's often missed is the substantial change of circumstances has to relate to the issue that you're seeking to modify. Now, that may seem commonsensical, but in some cases it's not. And most specifically, I've seen it erroneously applied or erroneously missed in custody cases. The substantial change of circumstance for the best interest of the child standard for custody will often be approached by people saying things like, moving, I have a new job and child support needs to be modified, I haven't got a cost of living adjustment in a lot of time, if I move to Florida, I'll have better job and family support. Those are all great issues that do go to change of circumstances, whether or not they're substantial, but they're change of circumstances, but none of them relate to the child. So if those examples I just gave you were used to support a modification of custody, they probably would all be denied because they have nothing to do with the child. So you want to make sure in that case, for instance, that it deals with the child and that it shows a substantial change in the circumstances. Next, with regard to paper, and this goes from before and after, keep organized records. If you're going through a divorce now, keep notes. Every time you go out, keep notes. Keep your emails. Keep them in a file. There may be tons and tons. Keep them. Most importantly, when you're going to modify an agreement, you have to show what was intended when the agreement was reached. They don't always spell out exactly word for word every foreseeable condition or change. A lot of times there's a lot of ambiguous terms that need to be reviewed, and you can't just put in certification, well, we meant for this, or when we said holidays, we meant Christmas and not Hanukkah. If you had notes and emails on your paperwork or in your files, then you can go and actually say this was what was intended and actually have some proof. Moving on with more do's, again, we're going to talk a little bit more about some of the paperwork with a little more detail. So, case information statements that I mentioned a moment ago. You want to attach in most, and again, I have to give a caveat. A lot of my discussion today is going to be about modifying financial obligations, alimony and child support most commonly. That's the most common and difficult application for modification. So going to that, attach all prior case information statements, relevant judgments, and orders. Not necessarily, I mean, you do need to put all that relate to the issue. If you have a lot of orders and judgments that don't relate to your issue, you may want to attach them, you may not. That's kind of a judgment call. Maybe you want to put them as a separate attachment. But the thing to remember, or not to remember, the thing to know about this, and a lot of people that aren't attorneys don't realize this, is that judges don't necessarily get your whole file. So if you file a motion to modify your judgment of divorce and you don't attach it, the court doesn't have a copy. They're not going to go to the file and read it. If you have a consent order that came after your judgment of divorce that modified support, they're not going to go and get that either. So you need to attach it because the court's going to require all of this and they're going to need it. If you don't have, and obviously get these long before you file, which goes back to my point about filing early and planning early. If you don't have them, reach out to your prior attorney. A lot of times they do keep files. They should keep files for a number of years. The courts can sometimes help you. They often have copies of documents, or Trenton can help you retrieve certain documents. Not the best course to go to, and obviously they only keep them for a certain amount of time, but it's one option at least. Document everything in writing and attach proof. Sort of what I keep saying is that don't just say things. Don't just write a certification. Anybody can write a certification and say this has happened, or I think he's working and making more money. That doesn't work. You need to attach what's going to prove it. Attach what you had that shows what the circumstances were before, and attach proof that shows what they are now. Don't expect a judge to just accept and believe what you're saying because you put it in a certification. And more importantly, as I said before, be prepared to go to a plenary hearing. As I said, the time frame we're looking at is a year. But when I talk about be prepared, I mean be prepared for what it's going to take, like the time you're going to go through discovery. You're going to have depositions. You may have to go to trial. You're going to be missing work. You will likely have significant legal fees if you have an attorney. You may have costs of the discovery, like deposition transcripts. You need to know and plan for all this. You need to make sure you have the vacation time so that you can take off. You need to make sure you have the budget so that you can pay for the deposition transcripts. If you start a process that you can't finish, you may just be wasting everybody's time and a lot of your money. And when you focus the issues when you're planning for the plenary hearing so that it zeroes in on only what's important. Like I said, when you prepare the paperwork, same thing when you're preparing for a trial. Focus just what's on the issues. I see a lot of attorneys that don't even know how to do that. They're so busy trying to prove a point that they don't get to the real issues. You don't have to prove everything at trial. You don't have to prove, for instance, that everything the other person says is a lie. You only need to prove what's important to your case. More do's. As I said in the beginning, a lot more of what to do than what not to do. I think we'll get to some don'ts coming up, but not a great deal. I think it's safer just to follow what is positive. Obtain and provide the court with appropriate documentations of the circumstances of your case. Now, I know this sounds a lot like what I've been saying, but this goes to what attaches to your papers. As I said a moment ago, attach your case information statement, attach your orders, but also attach whatever is going to be appropriate for the circumstances of your case. Don't feel that you're putting in too much or too little. If you're filling out a case information statement and it asks you to put on your tax returns, you can also put in your bank statements, your credit card statements, your food bills, anything that supports the information you put in your case information statement can be attached to it. Anything that you mention in your certification, you should have attachments. And the important thing to realize at this point is the court rules limit how long your typed certification can be. And the certification is the part where you do your talking, your arguing, or whatever it is. It does not limit how much you can attach to it. So you can get a lot more evidence before the judge by attaching the appropriate documentation than you can by actually saying what you have to say. Now, here's a list of things that you need to consider. Several of them relate more to support and custody issues. Most of them I actually would probably support and custody issues. Some of these, for instance, you're going to look here. When you talk about things like medical and tax returns, things like this, you need to contemplate specifically because you may need to get authorizations. You may need to get HIPAA releases. And you can't do that until you have litigation usually underway. So you might want to plan this and discuss this with your attorney or possibly the other side. Going to my comment before about trying to settle beforehand, you might even want to engage in some kind of paper exchange. We call it discovery. So that you get some of it before you actually walk into court. Now, along those lines, some more do's about when you go to court, what are you going to be doing? First, ask the court to order the party to provide certain things. The list that I gave you a moment ago, I indicated there are going to be certain things you're not going to be able to get. Updated income, other information like medical releases, tax returns, these are all confidential. And the interesting thing about, well, not interesting, but the complicated thing about some of these issues, like income information, is the modification of support is based on change of income, but you can't get a change of income unless you have a court process. You won't get a court process unless you first show a change of income. So you're in this catch-22. You believe your partner or your ex-spouse is making significantly more based on their lifestyle, but you have nothing to prove it. And you can't get that proof without going into court. And this is where attaching documentation like the car that they're driving, the tax statement of the value of their house, things like that. Attach anything so that you can show a change of circumstances, even if you don't have the actual documents that you need. Along these lines, consult with an accountant and other experts. Again, in advance. Do this before you start filing papers. Talk to an accountant. Get some kind of report of what the basic income for a person would be, or how a business is evaluated. Find out from the Department of Labor basic statistics. And work with these experts to craft your argument and the support for your argument before you go into court, even though you may end up having to hire different ones afterwards or even separately. But you want to speak to specific experts that are going to help you with specific issues. One good example, private investigators for cohabitation claims. Cohabitation is a very, very challenging thing to prove in court. It's very rewarding and beneficial if you do, but it takes a lot. You want to speak to private investigators, find out how much it costs and what kind of surveillance, because you want to get as much as you can from any expert really. But when it comes to a private investigator and a cohabitation modification, you want as much proof as you can afford to get before you go in, because you have one chance to get the court to schedule a plenary hearing on that, and you can't tip your hand until you do, because if they find out you're trying to modify for cohabitation, they're going to stop cohabitating. So I don't think I have more on do's coming up. So let's talk about what not to do, the don'ts. First, foremost, most important, do not exercise self-help under any circumstances. Self-help is you're choosing to disregard an order in any way that is, whether it's you stop making an alimony payment because you lost your job, or you don't bring your child back to parenting time because you think the other parent is a harm. There are several reasons. My next slide here. For instance, not paying support, like I was starting to say before. Judges do not like or respect somebody does it. It brings, not only, first of all, practically speaking, puts you in contempt of the order, but more importantly, not that there's anything more important than being in contempt of the order, but I think it really damages the credibility of your case. It damages the credibility of your person, and you're going before the judge, and you need them to trust and believe in everything that you have to say. And this is another point, sort of goes to what I was saying in other ways with documents. Don't expect the judge to read your mind. Be clear and concise about your points, attach and explain everything. Just because you think something is clear, like your spouse was making $50,000 when you divorced and now he's making $100,000, and you think, well, just because twice as much money, that's a significant change in circumstances. That may not be. To you it may be. It may or may not be to the judge. His or her lifestyle may have increased. They may have had another child. There could be a million things that negate what you believe to be significant. You need to explain why the facts of your case match the law of your case. So do not expect the judge to just understand that. The next one, and I say this time and time again, if people follow me on Facebook, they see my my daily texts. I post a divorce and family law tip of the day every day, and I say this on and often. I say this to every client. Don't send any emails you do not want a judge to read. And this is not limited to just emails. This is limited to any kind of communication. Don't send a text message because there's a photograph of it. Don't leave a voicemail because they can be saved and forwarded unless you want the judge to hear it. I don't care how angry you are. I don't care how right you think you might be. Nothing can hurt you more from a proof standpoint and a credibility standpoint than a nasty email or text message. And these things get saved forever. Which will bring me to my next don't. This I even put into my retainer agreement so the clients are aware of it. Don't post on social media at all. Don't post anything about social media. If you're going into a modification, look, even if you're in a divorce now or a contested case of any kind, don't post on social media. Not only is the history saved, so, well, I'll get to that in a second. When you post on social media, not only can many other people see, sometimes your adversary, but it will do things that you may not realize, like it'll say where you are. It'll have pictures behind of who you're with. It will carry implications that suggest you're able to do one thing when you're saying that you might not. And even though that might not be the case, like for instance, if you're on disability, and I'm going a little off topic of family matters, if you're on disability but you're seen, dancing in a bar or at a club, that might suggest that you're quite capable of doing something that you claim you're not. It may not prove it, but it certainly doesn't help to have it out there. Along the same lines, do not delete anything that's on your social media if you've posted something that you now regret. One, it's tampering. It can be considered tampering with evidence. That could be serious. It could even be criminal in certain cases. But the history is saved. They are able to access whatever was on social media. Now, I don't know exactly how. I learned this at one point in time just from an evidence standpoint. I don't know how it's done, but I understand that whatever is posted on any social media sites is saved in a certain method or certain way that can be extracted and utilized. So if you have something that's out there that you don't want people to see, don't take it down, because it's even worse if you do it that way. Next, don't instigate litigation without a realistic plan. As I mentioned before, talk to experts, talk to an attorney, figure out what it's going to cost you so that you don't start something that you can't finish. If you put money into experts and you put money into legal fees and you take it off work, you have to make sure that you're going to go somewhere with it. In a lot of cases, as I said in the beginning, some people may have signed on a little later. Sometimes it makes more sense to take the money that you might be spending in the litigation and put it towards the settlement. If you're trying to cut your child support by $50 a week, don't spend $5,000 in legal fees. It doesn't make any sense. You'd be better off just paying that, you're keeping it and paying the child support. So have a realistic plan. Along those lines, don't be unrealistic in what you think a court can and can't do. Don't expect that just because you found that your spouse was living with somebody that they're going to get zero alimony, even though they have permanent alimony. They may get less, but they may still get some. The court may give an order that you couldn't even foresee happening. Time and time again, in the 20-some years I've been doing this, I've had a judge render a decision that completely shocked me and my client, that we had just no way of knowing that the judge would even be focusing on this issue. I tell all my clients, you can't place emphasis and hope on what you believe the judge should do. There's no such thing as fairness. There's no such thing as justice. Everybody's definition of that is going to be different. So just because you think something is fair, don't expect that a judge is going to think it's fair and do what you want. It could just be in the opposite. I've even seen cases where people go in to modify support and it goes up. Child support, most commonly. If you don't run a good income analysis, you may end up running into where you're paying more support than when you first entered it. Let's talk a little more about don'ts. Don't compare your case to your friends or your relatives. Everybody's going to have that horror story. Everybody's going to tell you about their friend that had this and did this and got this or didn't get this. Every case is different. So you never know. Your case is not going to be anything like any other case. I've had thousands of cases. No two of them are the same. I went through a divorce myself. My case was different than every other case I've handled. You just never know. So just because somebody else tells you that something did or didn't happen or isn't going to happen, don't. Everybody's case is fact sensitive. Every case will be different based on the specifics of that case. Next. Now, this may seem contradictory. Don't hire an attorney. But specifically, don't hire somebody just because it's inexpensive. Don't hire somebody because they give you a promise or a guarantee. That's unethical and impossible. So if you meet an attorney who says, yes, I'll modify your alimony and it'll cost you X dollars, don't go there because nobody can guarantee you anything. The less an attorney promises, probably the better the attorney is. So you want to be careful. Attorneys, unfortunately, many of us, including myself, we're running a business, and clients are what provides that business revenue. You have to be careful to make sure that you're getting somebody who's really committed to your case and really knows what they're doing. Next, may be a little hard to understand. Don't come to court with unclean hands. So what does that mean? Unclean hands is a term of a legal term of art. It's in the family court, which is considered a court of equity. Court of equity means it's considered a court of fairness, and it's not just limited to the four corners of what a document says or what the black letter of the law says, but the courts can expand it for cases that may not fit within the guidelines, or if somebody was harmed because they were promised something and there's not really a law that protects them, the court can expand it in this kind of a court, like the family court. Unclean hands means don't do something dirty and then come to court. Don't, for instance, cut off support and then come in to modify it. Don't, threaten to kill somebody in a text message and then file a domestic violence complaint saying that you're afraid for your safety. Take the higher route before, because it will certainly come back better or worse for you when you get there. So I'm going to turn to questions in a second. I do have like one or two closing points I didn't mention in the handout itself. One is I mentioned about the new law. I discussed the new alimony law in the beginning. And the thing about the new alimony law is in some cases it doesn't apply to prior settlement agreements by the terms itself of the statute, but also the agreement itself. Most agreements can be argued that absent specific language in the agreement, no new law or change should apply. Most agreements don't contemplate changes in the law. So there's always that caveat that you're seeking to modify or you're seeking to defend on a modification. Let's say somebody's modifying because the law has changed. You can argue easily the agreement itself doesn't suggest that it can be modified because the law changes, so it shouldn't be. So it's an important point. Don't just get hung up on the law, but look at sort of the contract, look at the agreement itself. Second is, this goes along the lines of what I said a moment ago about not going to friends. Don't go to the internet, which may seem odd because you're on the internet now, but don't go to try to find your own answer to a question like modifying a family court agreement or terminating support for cohabitation. There's far too much information out there to be able to process it. And if you try to, you're going to be overwhelmed and you're probably going to get the wrong answer, which is even worse than not getting an answer at all. Now, I'm going to turn to the questions I had suggested that you post during. I was given some modification questions before, so I'm going to jump into those. Anybody else that has any, just post them up in a little section in your control panel on the right side in the middle where it says questions. You should just be able to type in there. Where it says type, I think it says type answers here and then send to all or send privately, doesn't matter to me. So the question I got here, and let me first premise before I answer these questions, modifying any agreement or order is very difficult. The standard for any modification of any agreement is very high, and I didn't say that through the webinar, so it's important to realize that make sure you have a good, strong case because it's just not a change. It's a substantial change that is usually required to modify most agreements. So with that backdrop, the first question I was given is, can you modify the payments to include cost of living increase each year? And maybe, maybe not. And that's unfortunately going to be the answer to a lot of questions. First, we have to look at what the original agreement says. Like I said a moment ago, if the agreement doesn't contemplate changes, you may not be able to get something that seems standard. Cost of living is standard. Secondly, if you just are asking for cost of living because times have changed, the case law does not suggest that that is an appropriate reason to modify support, especially child support. I think the case law is clear that it says you cannot modify simply for a cost of living because time has passed. But now, if you want to try to do that, a better way to do it is to have payments paid through probation, the probation account, or through wage execution. It goes through the probation account because the probation account, I believe, automatically adds cost of living adjustments every 2 or 3 years. So you have a better chance of getting a wage execution because the courts favor that because they prefer child support to be collected automatically. And then you automatically get your cost of living adjustments. Let me just take a quick sip of whatever here. All right, so the next question I have is, can you modify the agreement to make auto transfers of payments to personal checking accounts rather than payments by check each month? Again, it's going to be the same answer. First, it's going to depend on what your agreement says. If your agreement doesn't provide for it, probably not. And also, the nature of this question sounds like it's a convenience factor. Instead of getting a check, you want money deposited into your account. That's more convenient for you. You're not likely to get that. Convenience is not going to be considered, or even inconvenience is not going to be a change of circumstances. If they miss some payments, it's not going to be a substantial change of circumstances. I think a change like that may only come if you have chronic noncompliance or you have contempt orders. Then you can say, because that person has come with dirty or unclean hands, that maybe the court should now modify the agreement to have it paid a different way, either by direct deposit into your personal checking, or to the earlier question, giving cost of living adjustments through, or giving a wage execution or a probation payment, sort of a backdoor approach to it. Next question is, if monthly payments are not enough to live on, can you ask for an increase? Same thing. Well, the simple answer is no. I mean, if it's not enough to live off of, that's unfortunately probably just too bad. If there's been a significant change of circumstances that now render the payments insufficient, then it's a fact-sensitive question. You have to look at what your agreement says, you have to look at what the law says, and you have to contemplate what the potential outcome is going to be. So that really kind of embodies everything that we've talked about today. Most support payments aren't going to be enough. You know, it's just nobody ever offers or gets enough to live, beyond their needs, but it still always will require a fact-sensitive analysis. Next is, I think this is a question, it's, can any modification be done by an individual, or does it have to be an attorney? No, you always have the right to represent yourself. I never recommend it, not because I am an attorney, but because going to court without an attorney in a complicated case like this is just a very challenging thing. Not even just from the standpoint of knowing what to write and what to file, but standing in court on a personal matter without any experience of handling these things. Listen to a judge speaking while you're thinking about what's going on and preparing to speak, and then being able to speak intelligently is very, very trying. So while I don't recommend it, you're certainly free always to do it. Let's see, there's another question up here. Just got to get my pointer. All right, 1 second. Question is, I'm paying permanent alimony. How far in advance of retirement do you recommend beginning the process to try and modify? Well, again, it's a hard question because I don't know how long the term, or you said it's permanent, I don't know how long that really means. I don't know how long you've been paying. I would say, without more information, that when you know that retirement is a real potential, then I would do it. If you're 60 and you're going to retire at 65, don't do it. It's way too early. You might start planning for it now, gathering documents and tax records, social security statements, things like that. I hate to say 5 years, but the more planning, the better. But I wouldn't file anything at least a year or two before when you would actually be sort of pulling that plug. If you're going to retire at 65, file at 63. Or at least when you can find that you would be able or allowed to retire. So you might even be at age 65 or working past 65. You could do it. But I would wait until you can show that it's a realistic, even though the statute, like I said, for alimony allows for an anticipatory retirement, it needs to be a realistic anticipatory retirement. All right. I don't see any other questions. I'm going to hang around for another minute. Oh, wait, you know what? Actually, before I do that, instead of cutting off, I'm going to launch a quick poll just to get some information from those that are here. And again, your information is kept confidential to me. It's just so I can see how effective these webinars are. So if you take a second, and there should be a quick poll question on your webinar screen or on your computer screen. Just take a second to answer for me, please. Excuse me. Okay, that's interesting. All right, next. Is this a good time for these webinars? I go back and forth about changing the time. All right, I'm going to close that. Don't want to keep you here too long for that. All right, well, that's good to know. Moving forward, just a couple more. Again, these answers only stay with me. This just helps me understand my audience. I'd like to know whether or not you're actually going through a divorce or if you're past one. I do see there's a question post. I will get back to that for you. I'm just going to finish the polls first. All right, this one I'm not going to launch just out of respect for everybody here. Basically, was there anything that you feel we didn't cover, or did we cover everything that you thought would be helpful? All right, good to know. Good to know. And by the way, if you didn't, and I don't get to a question, if you think of a question afterwards, which I will take a moment after these to answer questions. But if you have a question when I close up, just send me an email. You have my email from this webinar, and I'll answer those questions. Here's the last question from my end, and I'll get back to your questions in a second. And again, this doesn't go anywhere but to me, so you need not worry about your responses. All right. That also, out of respect for everybody, I'm not going to post just before I return the questions. Okay, so I have another question up here. Can change of parent of primary residence NR, I guess I think that means, or forced for child back to parent of alternate residence across state back to New Jersey in emergency circumstances where there is no time to go back to court. I'm going to read the question again because I'm not real clear on it. And I'm going to read it verbatim out loud so that can change of parent of primary residence NR forced for children back to parent of alternate residence across state back to New Jersey in emergency circumstances when there is no time to go back to court. I don't know what that question means. It sounds like, are you saying, and I'm not really sure how this relates to our topic, but I'll certainly try to answer it for you. It sounds like you're asking, can a child be returned either to New Jersey in emergency circumstances where there's no time to go back to court, or can there be a change of residency when there's no time to go back to court? There can't really be any change without a court order to any kind of custody arrangement, absent the involvement of DCP&P, Division of Child Placement and Permanency, or what used to be known as DYFS, Division of Youth and Family Services. Absent their involvement, I don't know of any reason that any kind of custody can be changed, or any kind of parent of the residence status can be changed, or a child moved between state lines. So while I'm not really clear about your question entirely, I feel certain to say that nothing can be done without a court involvement. If that doesn't answer your question, feel free to either send me an email with it or call my office tomorrow and we can schedule time to discuss it. I'm going to, like I said, hang out for another minute or two to see if there's any more questions that get posed. I'm going to double check, make sure I didn't miss any. Any questions? Going once, going twice. All right, well, I want to thank you for taking this time with me this evening. I'll remind you also that you can see past webinars at my website, micklinlawgroup.com. I'm sorry, I don't know what my next topic for next month is, but it will likely be on the last Thursday of the month. My website also does have the upcoming webinars. When you go to micklinlawgroup.com, under the webinar page, there'll be upcoming webinar page and a webinar archive page. So the upcoming ones will give you the list of what's coming up. In the archive will let you review the ones I discussed here tonight, as well as the other ones that I've done in the past. With that, I'm going to wish you a good night, and I hope to see or speak with you soon. Goodbye.